Welcome to HIT Podcast, H.I.T, Human Resources, Insurance, and Technology. I'm your host, Toby Kennedy. As we do every week, we're dropping into your feed with what I hope are bite-sized, digestible, well-curated conversations going on in the space. This week's episode is brought to you by Montage Insurance Solutions. And without any further ado, I get into part two of my conversation with Brian Koegle. Brian, thank you so much for joining us. If you missed part one, last week, we did Brian's amazing intro. We talked about how he's been on the show before, so you guys already know the man. And we did a lot of sort of what's new in 2026. But having a legal expert like Brian, and after we filmed last week's episode, he's like, man, that's a lot of content for like 15 minutes. I'm like, I know, that's the whole point of the show. So thank you guys for joining us. We try to jam in lots and lots of really great poignant information. So if you're in human resources, if you have a friend in human resources, like, subscribe, share. We're going to constantly come at you with great content. And this week will be no exception. Brian, you are at Koegle Law. You're the man with a plan. We'll throw up how to get a hold of you later. But one of the things we want to talk this week while we have a little bit of time with you is, hey, what are some of the things that as an employer are tripping folks up a little bit, and you still see, hey, listen, in my years and years and years of practice, this one really seems like one that I get quite a bit of phone calls on, or people are kind of tripping up a little bit.
Yeah, and really I narrow it down to three of the biggest problems that we get the most calls on throughout the year.
Love it.
Drop down to record keeping and documentation on one hand. Leaves of absence are still such a crazy overlap of multiple laws that folks are getting wrong. And then the third, wage and hour compliance.
Yeah, so, I feel like each and every one of those is like a full day seminar at a legal conference. So if you could get everything everyone needs to know in 12 minutes on those three huge topics. Yeah, no. So give us some of the highlights and say, listen, if you're going to trade us 10, 15 minutes of your time, I want you to hear 10, 15 minutes of these nuggets of information on these three wildly important topics.
Absolutely. So the first primary issue is documentation. Yep. Folks, if you're not documenting, I need you to understand it doesn't exist in the law. All right. If it comes down to a he said, she said with an employee saying something happened and your team saying something didn't happen, you lose every single time unless you've got documentation. And unfortunately, what it comes down to is we're only as strong as our weakest link. And most times our weakest link are our managers or our supervisory level. They just don't like that part of their job. They don't like to have to document disciplinary action or attendance problems or a communication or correspondence that they've had with an employee about needing an accommodation. The problem we run into is if we've got one weak manager, I can almost guarantee you that's going to be the area where an employee comes forward and says, but I told my manager 6 months ago that I have this disability and I need an accommodation. Or, the reason I missed so much work is because I was attending doctor's appointments to care for my ill child. The more communication we have in writing by and between our employees and our supervisory staff, the better off we are. And this doesn't have to be formal, Toby. It can just be a 2-line email from the manager to the HR team saying, today I spoke with Tom. He told me he needed to take a couple days off next week because his kid's been really ill. I asked him to bring in a doctor's note to say that that's why I was missing work, and I'll give it to you as soon as I get it.
Yeah. And then how about letting managers know how important this is? Would you recommend an actual formal training? And by the way, if you do, do you have to document the dang thing because of some other rule coming down or?
Well, Toby, that's a great segue to our first session, which says that any training sessions that we provide to our employees, we now must maintain documented records of those in the personnel file. I absolutely encourage you to train and retrain managers. Candidly, I don't believe annual training is enough. Yeah. What I would rather see is one formal annual training and then reminder emails from HR. Guys, we've seen more attendance problems, especially as we head into the holiday season. Please make sure we're keeping track of attendance through our payroll system or through our HRIS system. Yep. Make sure that we have this properly recorded so that it's properly set for payroll and that we have a record so we know when people are missing work.
Yeah. No, that's a great note. Okay, so documentation, as you said, it's one of those things to where it almost is like real estate when you hear the top 3 rules and people say location, location, location. Whenever I hear someone in HR or the law talk about documentation, they always say it like they're calling Beetlejuice. They're like, listen, if I say no, documentation, 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 like it literally can't be said enough. So I'm
That's
glad
right.
you're starting out the gates with that. And even like a good actual tangible takeaway of like, hey, look, doesn't need to be formal, 2-line email, save it, add it to your manager's training once a month or once a quarter. Just kind of, hey, at the opening of every meeting, we're just going to spend 5 minutes reminding everyone, please be on it, guys, a little bit of housekeeping, etc.
Precisely. Couldn't agree with you more on that. So the second big issue that we want to touch on today is leaves of absence, because this has become one of the biggest pitfalls for California businesses, well, really businesses across the nation, that are facing how to comply with various leave laws. What do we do with the situation where we have an employee who's pregnant? Or what do we do if somebody's got a workers' comp leave that overlaps with FMLA? It is imperative that you make sure that you have a policy and procedure in place so that your team knows which boxes we're checking for each and every different type of leave of absence. Additionally, I like a little cheat sheet. I call mine a checklist, but a little cheat sheet so that everyone has the groups of leaves, who gets what and when we have to make sure that we're notifying either HR or higher level management on when someone is going to be gone for more than 2 or 3 business days during a work week. We need to make sure we've got workflow. We need to make sure that somebody's covering that desk if somebody's going to be out for an extended period. People need to communicate, but understanding leaves of absence is really a critical element for any business.
Well,
Because
and which ones like stack on top and which ones run concurrent, right?
correct, exactly. And the problem is, if you don't have that kind of master sheet,
Right.
people are just going to go off of their memory. And if one of your supervisors gets one of these cases wrong and they go, oh, well, that's pregnant employee, they're only entitled to 12 weeks. They're not entitled to anything more. No, you're wrong. And what that does is it creates legal liability, and that employee who is not provided all of his or her guaranteed leaves or protected leaves under the law, you know what we call those people? We call them plaintiffs in lawsuits.
Yeah, yeah. And if a bunch of them get together, we call that a big problem.
We call that a class action. That's exactly right.
Okay, so kind of top things for folks, and maybe a good like subtitle to this is like, hey, HR, these are 3 areas to make sure you brush back up on. Or if you've got a junior HR person under your tutelage, letting them know, hey, listen, this will be something that will constantly be sort of a burr in the saddle. So just, really getting yourself expert on this would make you very valuable to companies and HR departments.
100%. And then the trickle down effect from there, right? HR may have all the nuts and bolts and have everything in line, but if the managers aren't communicating it to the line level workers, then it's no good to us. The policy doesn't help us. We need to make sure our managers are well trained, that they understand what the rules of the road are, and that they're implementing it on a day-to-day basis.
And so maybe a good takeaway here for the leaves is ensure that you've got a good, clean, at a glance cheat sheet or sort of master graphic. And if you don't, reach out to folks like Brian Koegle. And if
Absolutely.
not, create one or look for one, but constantly sprucing that up, because doing this off memory is just a fool's errand with how many things are overlapping and in the soup.
Couldn't agree with you more on that one.
Okay.
Yep.
So we touched upon a couple of the biggies, but I think that there's, a biggie left for third.
A huge one. Yeah. Yeah, and this all comes down to wage and hour compliance, Toby. And unfortunately, this continues to be the largest issue of exposure for businesses throughout the West right now. And compliance with ensuring overtime is paid, that meals and rest periods are provided, that documentation of actual time worked. Guys, for those of you that have businesses that do business in California, we are moving all of our clients to minute compensation systems. This has been kind of trickling about since the Trester versus Starbucks decision 4 years ago, but we're waiting on this decision called Camp versus Home Depot from the California Supreme Court that basically is going to do away with rounding time and require all employers to track minute-to-minute compensation and pay their employees accordingly. As these things occur, Toby, the problem is it's going to be the next big wave of litigation, right? And already this year, we're on pace for 2025 to have 8,900 new PAGA cases,
Oh
Private
my
Attorney
God.
General Act claims, filed in the state of California. Almost all of those have a component of wage and hour compliance. These numbers have been increasing basically for the last 10 years, but especially since the COVID pandemic.
Yeah.
We're seeing the numbers jump. During COVID, it was like 7,100 cases, I think, were filed in 2021. Now we're all the way up to 8,900
Right.
per year. And these are new filings, new cases. And
Well, and
remember,
I've heard people say that it's one of those things to where you've got some kind of employee that's maybe not particularly knowledgeable about all the facets of the law that says, my employer fired me for no reason. So they call the attorney like, hey, I was fired without cause. And the attorney's like, well, I'm not sure that's really a thing, but talk to me about your meal periods. Talk to me about your rounding, right?
100%. That is exactly what these attorneys are doing right now, because it's a very lucrative practice for plaintiffs' attorneys to take on these PAGA matters. They're getting 1/3 of basically a group of individuals' claims. And again, it only takes one aggrieved employee to come forward and bring a claim on behalf of anybody who has worked for you over the course of the last year prior to the time that they bring their claim
And this
forward.
is you unpacking PAGA a little bit, right? Just so if someone's listening and they're
Unpacking
not
PAGA a
100%
little.
sure can you just give me like another 35 seconds on what PAGA is or stands for?
Yeah, it's the Private Attorneys General Act. And what it does is it basically deputizes any one of your employees to stand in the shoes of the California State Attorney General to bring a wage violation claim under the California Labor Code. So basically, they're working on behalf of the state of California saying, we're enforcing the labor code against your business because you're not following all the rules of the road.
And the reason this becomes particularly germane now is you used to be able to round hours a little bit better, or and you tell me, I mean, I don't know how long ago this was, but like to the 15th of an hour, a quarter of an hour, or whatever. And now you're saying they're getting so tight on the matter that they're literally going minute by minute. And whether this becomes official based on the Home Depot court case or not, you guys are already moving forward with advising your clients to say, hey, listen, nobody wants to be the employer that's doing it the old way when you got a bunch of hungry attorneys looking to say like, hey, Mr. and Mrs. Employee, you've already been deputized by PAGA to really go after the employer, and also the rules have changed, so you might catch them flat-footed.
That is correct. And especially because the last four major decisions that have come from our California Supreme Court have had retroactive application.
Love it. Great.
Meaning
Even better.
it goes back a period of up to 4 years on a class action. If they interpret this, let's just call it in January,
Yeah.
they can look backwards to January of 2022 for any sort of violation.
So they tell an employer, hey, you didn't know that now? Well, did
Yep.
you also not know it 4 years ago?
Yes, exactly. Exactly.
Oh, golly.
So that's why we're trying to get employers cleaned up now, getting their payroll processes and procedures in place, updating how they are managing employee timekeeping, making sure that those records are accurate, complete, and thorough on a weekly basis. And then finally, Toby, I am a huge advocate that every employee should have an opportunity to review their time at the end of each pay period. And before they submit it to payroll, they sign a certification. And the certification says something along the lines of, all of the hours reflected above are true and accurate to the best of my recollection. I received all of my prescribed meals and rest periods during this pay period, and I did not sustain any known on-the-job injuries.
I mean, that's good thorough stuff. That's what you get from when the attorneys get to look this stuff over. You start adding a couple bits of language to just kind of make sure you're bowling with bumpers on to the extent possible.
100%. And what it does is it's just very valuable evidence for us to fight back a claim of missed meal periods or incomplete time records, etc.
Yeah. Yeah. Brian Koegle, ladies and gentlemen, the best 15 minutes under 15 minutes on the internet in the legal space. How do we get a hold of you?
Well, listen, anybody can reach out to me anytime. You can call me 661-362-0813 is our direct line. You can reach out to me via email at bkoegle@koeglelaw.com. That's bkegley@kegleylaw.com. I'm on all the social media platforms, including LinkedIn, Instagram, Twitter, and Facebook. Additionally, my law firm is available through our website inquiry system as well, which is kegleylaw.com. So feel free to reach out to me anytime.
Thank you for being so generous with your wisdom and your knowledge. I appreciate the heck out of you. And that is all the time we have for you guys on this week's episode. Join us next week. Thank you to our sponsors, Rula, Excel Health, TrueHue, Montage Insurance Solutions, the guys keeping the lights on. Really appreciate it. We're blessed to be here. We see the numbers go up every week. We thank you guys for liking, subscribing, sharing, telling a friend. Join us next week. Join us every week. And until next week, make this the best week yet.